Are you feeling overwhelmed by the idea of trusts and unsure if they're necessary for you? Maybe you're asking yourself, what exactly is a trust? And do I need one? And if so, what type of trust do I need? In the next few minutes, I'm going to answer all these questions in simple terms and help you decide what's right for your family. Hi folks, I'm Jim from ELM Legal Services. If the word trust makes you feel like you need a law degree just to understand it, you're not alone. We speak to people every day who are confused about trusts, unsure whether they need one, and confused by the different types. In this video, I'm going to clear that up for you. I'll explain what a trust actually is, how will trust and lifetime trusts differ, and when you might want to consider each. So if you want to protect your home, support your loved ones, or just feel more confident about what happens to your estate in the future, stick with me. Let's dive in. So what exactly is a trust? Well, a trust is a legal arrangement that lets you safely manage your money, property, or valuables. Here's how it works. You, known as the settlor, place your assets into the trust. Then the people you choose, called trustees, take care of those assets for the benefit of others, known as beneficiaries. The trust clearly explains how and when the assets should be used or passed on. This means you stay in control of who receives your assets and when, even after you've passed away. Trusts are a way to protect your family and make sure your wishes are carried out exactly as you want. There are two main categories of trusts: will trusts and lifetime trusts. Each type serves different purposes and offers different benefits depending on your personal circumstances. Understanding these options can help you choose the right way to plan for your estate and protect those you care about. A will trust, also called a testamentary trust, is a legal arrangement that's written into your will. It only comes into effect after you pass away. It doesn't actually exist during your lifetime, and you can change or remove it at any time before death. Will trusts give you control over how and when your assets are passed on, and they're especially useful for achieving the following goals. Number 1. Avoiding sideways disinheritance in blended families and second marriages. If you're in a second marriage or have a blended family with children from a previous relationship, simply leaving everything to your spouse might feel like the most straightforward and loving choice, but it could unintentionally result in your own children receiving nothing after you're gone. This situation is known as sideways disinheritance, and it's one of the most common estate planning pitfalls we come across. Here's how it typically happens. When you leave your estate directly to your spouse, they become the sole legal owner of those assets. So after you die, they are free to change their will at any time, and that new will might leave everything to someone else. This could include their own kids, a new partner, or even a charity or friend. Even if they've actually promised to do the right thing, there's no legal obligation to stick to that promise once you're gone. Things get even riskier if your spouse remarries. Under the law in England and Wales, marriage automatically revokes any existing will. So if your spouse remarries and doesn't update their will, then passes away, their estate will be distributed under intestacy. These rules don't recognise stepchildren, so your own children from a previous relationship may be completely left out, with everything passing to the new spouse or that person's relatives. Even if there's no remarriage, dying without a valid will leads to the same problem. Intestacy rules favour biological and legally adopted relatives, not stepchildren. So again, your children could be bypassed entirely, and then there's the emotional side. Relationships can change over time. Your spouse may have a good bond with your kids now, but grief, distance, or a new family might cause that relationship to deteriorate. In some cases, even well-meaning intentions can shift. That's how original plans quietly fall apart. It's important to understand that sideways disinheritance is rarely intentional. In most cases, the surviving spouse simply doesn't realise the legal consequences of their actions. Life moves on. New relationships form. Priorities shift, and estate planning gets pushed to the bottom of the list. Unfortunately, this natural course of events can leave your children with nothing. The good news is that it's entirely avoidable. Using a will trust allows you to provide for your spouse during their lifetime while protecting assets to ensure your children ultimately receive what you intended. It's a practical, fair solution for blended families and one that gives peace of mind to everyone involved. Number 2, protecting young children or delaying inheritance until they're older. In England and Wales, children inherit in full at 18, unless your will states otherwise. That might not be ideal. Most 18-year-olds aren't prepared to manage a large sum of money, and an outright gift could quickly disappear through poor decisions, peer pressure, or scams. A will trust lets you delay inheritance until your kids reach a more suitable age, such as 21 or 25. You can also allow for incremental payments or specify that funds are only released for things like education, housing, or health. Until then, trustees manage the money in your kids' best interests. Number 3, supporting someone who is vulnerable or has special needs. If you want to provide for a loved one who has a disability or struggles with addiction, poor money management, or receives means-tested benefits, giving them a large sum of money outright could do more harm than good. Now, a will trust lets trustees manage the funds and support that person in a controlled, flexible way without giving them direct access. It helps protect their inheritance from being wasted or affecting any state support they may be receiving. Number 4, shielding an inheritance from divorce or debt. Suppose your adult child faces a divorce or financial difficulties like debt or bankruptcy. Now, if they receive an inheritance outright, these assets become part of their personal estate and could be at risk of being divided in a divorce settlement or claimed by creditors. A will trust can protect that inheritance by keeping it in a separate legal structure managed by trustees. This means the assets aren't owned directly by your child and are shielded from being lost due to their personal financial issues down the line. For example, meet Amy. She wants to leave a significant inheritance to her son, but worries that he may face financial or marital challenges in the future. Amy sets up a will trust. This trust allows trustees to manage and protect the inheritance, ensuring her son benefits from it without the assets being directly accessible to him, and potentially vulnerable to future divorce claims or creditors. By planning this way, Amy safeguards her son's inheritance, helping it stay within the family and preventing it from being lost due to circumstances that might arise later. A lifetime trust, also known as a living trust, is a legal arrangement you set up whilst you're still alive, and it starts working straight away. You can transfer assets into a trust such as your home, savings or investments, and make yourself a trustee. This means you keep full control during your lifetime while gaining specific legal benefits. Used correctly, a lifetime trust can be a powerful tool for future planning. These are some of the key benefits it can provide. Number 1, avoiding probate for loved ones. When someone dies, their estate usually needs to go through probate, a legal process that can take months and delay the transfer of assets. It also often involves extra costs and administrative stress for your family. By placing key assets like your home into a lifetime trust, those assets sit outside of your probate estate. So when you pass away, they can be passed directly to your chosen beneficiaries without the need for probate at all. This can speed up inheritance, reduce delays, and offer greater privacy. Number 2, planning for long-term care costs. If you ever need care in later life, the local authority will take a close look at your finances to decide how much you must pay. And unless your spouse or a dependent still lives in your home, its value will usually be included in that calculation. In simple terms, this means your home, the one you worked hard to build and hope to pass on, could be sold to cover care fees. Now, with the average cost now reaching £1,500 per week, a lifetime of savings and the inheritance you wanted to leave your loved ones can disappear very quickly. Placing your home or savings into a lifetime trust may help protect them from being counted, but only if the trust is set up well before care becomes a foreseeable need and as part of a genuine, well-documented estate plan. If it appears the trust was created solely to avoid care fees, or it was set up too close to the point when care was likely, the local authority may treat it as deliberate deprivation. And in that case, they can ignore the trust and include the assets in your financial assessment. To help avoid this, it's essential to act early, ideally years before care is foreseeable, and record clear reasons for the trust which fall under legitimate estate planning, such as avoiding probate, managing inheritance tax, or planning how your estate will in actual fact be passed on. A lifetime trust can be an effective part of long-term care planning, but only when used properly, proactively, and with professional advice. If you'd like to learn more about the role of trusts in protecting your home from financial assessments, we have a video dedicated to the subject, which you can find linked in the description below. Number 3, gifting property without losing control. Many parents want to pass their home onto their kids during their lifetime, whether to begin handing down wealth, reduce the size of their estate for IHT, inheritance tax, or simply give their family greater certainty about the future. But understandably, most aren't comfortable just handing over the deeds. They still want to live in the property, retain control, and keep their options open. A lifetime trust offers a practical way to do exactly that. You can transfer the property into the trust, appoint yourself as a trustee, and continue to live in and manage it. This means you keep full use of the home, can downsize if you wish, and even receive rental income if it's ever let out. The trust structure ensures the property is protected and passed on according to your instructions and not left vulnerable to future relationships, disputes, or the probate process. And here's where tax planning comes into play. If your goal is to reduce potential inheritance tax, the 7-year rule is important. Under current UK law, if you place your property into what's known as a settle or excluded lifetime trust and survive for 7 years, the value of that property is usually removed from your estate for inheritance tax. But if you pass within the 7 years of setting up the trust, the gift may still be counted when calculating your estate's tax liability. So timing matters. The sooner you set up the trust, the sooner that 7-year clock starts, giving you the best chance of passing on the property tax efficiently without giving up control today. And if you'd like to learn more about the role of trusts and gifting your home, we have a video dedicated to the subject, which you can find linked in the description below. Number 4, flexible succession planning. Some people are happy to leave everything outright in their will, but others prefer a more measured approach. You might want to support a child with money over time, rather than giving them a lump sum, or perhaps you have concerns about a beneficiary's financial habits, personal relationships, or vulnerability. With a lifetime trust, you can set specific rules about how, when, and under what circumstances your beneficiaries receive their inheritance. Because the trust is active whilst you're still alive, you can shape its terms with more foresight and even update them if your family's needs change. For example, you might state that a beneficiary should only receive income from the trust until they reach a certain age, or until they finish university, or only if they're not going through a divorce proceedings or facing bankruptcy. The trust structure gives you the ability to support loved ones while still protecting the long-term integrity of the assets. This added layer of control can be especially useful in situations where beneficiaries are young, financially inexperienced, or simply not yet ready to receive a large inheritance. Now, let's break down the key differences between a lifetime trust and a will trust. These aren't just technical details, they affect when the trust starts working, how much control you keep, what happens when you pass away, and how your assets are treated in terms of probate, tax, and even care fees. First then, we have when it takes effect. A will trust only takes effect after your passing. It's written into your will and comes into force when probate is granted. In contrast, a lifetime trust begins working from the moment it's set up whilst you're still alive. Then we have control while alive. With a will trust, control while you're alive doesn't apply, because the trust doesn't exist until after you pass away. A lifetime trust, however, allows you to stay in full control of any assets you place into it, since you can name yourself as a trustee. When it comes to their impact on probate, a will trust does not avoid the process. Probate is still required to access your estate, including anything placed into the trust. But with a lifetime trust, assets transferred into it during your lifetime usually don't need to go through probate at all. In terms of protection from care fee assessments, a will trust is very limited in that regard. For the most part, your assets remain part of your estate for financial assessment purposes. A lifetime trust may offer protection if it's set up well in advance and as a part of a broader estate plan, not solely to avoid care costs. For inheritance tax planning, a will trust can be useful in certain situations, such as delaying inheritance or helping reduce the taxable estate of a beneficiary. A lifetime trust tends to offer broader inheritance tax planning options, particularly for larger or more complex estates. Finally, when it comes to complexity and cost, will trusts are generally simpler and more affordable to set up. For most people, a basic will trust might cost a few £100s. They're often ideal for straightforward family arrangements where some level of inheritance protection is needed. Lifetime trusts, however, are more advanced. They require detailed planning, professional drafting, and often long-term management. Because of this, they tend to be significantly more expensive, often costing several £1,000s. While the upfront cost of a lifetime trust is generally higher than other estate planning options, it's often a very sensible choice for those with larger estates, concerns about financial assessments, or a desire for more control over how their assets are passed on. When used correctly, the long-term advantages of a lifetime trust can far outweigh the initial investment. A will trust may be better if you have young children or vulnerable beneficiaries, you want to protect inheritance for children from a previous relationship, you want flexibility and aren't ready to move assets right now. A lifetime trust may suit you if you want to avoid probate and speed up inheritance, you want to shield your estate from financial assessments with appropriate planning, you want to retain control over assets while giving them legal protection. In many cases, people benefit from using both types of trust for different assets or stages of life. Trusts aren't just legal tools, they're a way to make sure your home, your savings, and everything you've worked hard for go to the right people at the right time, with less stress for your loved ones. Understanding the difference between a will trust and a lifetime trust helps you make confident, informed choices. And the earlier you plan, the more flexibility you're going to have. If you've got any questions about trust that we didn't cover today, please get in contact or drop them in the comments below. We're always looking to create content that's genuinely helpful, so if there's something you're unsure about, just ask and we'll try to feature it in a video. Thanks for joining us today. If this video helped, please give it a like, subscribe and share it with someone who might benefit. The more we can raise awareness about the importance of estate planning, the more families we can help avoid unnecessary stress and heartache down the line. Remember, a little planning today can make a big difference tomorrow. So until the next time then, stay safe, stay informed and stay tuned.